The following program is for informational and educational purposes only. It is not to be considered legal advice. Fraudsters Radio was created to expose the many scams and frauds that have so infected society today. Scammers, fraudsters, and rip-off artists abound, whether it's scamming homeowners with bogus foreclosure relief services, dating fraud, incompetent lawyers, or consumer rip-offs. It's high time the public has a voice. If you work in a profession that deals with fraud, or if you believe you were or are a victim of fraud, you now have a radio listening public that wants to hear from you. Please feel free to message us through our Fraudsters Radio Facebook page, and we may have you on the show as a guest. If you'd like to call in for today's show, the number is 646-668-8512.
And welcome to Fraudsters Radio. I'm Lori Z., nationally syndicated radio host and consumer advocate, along with my co-host, Storm Bradford, owner of Mortgage Fraud Examiners. Storm, we're going to have a really good show today. We've got an attorney lined up, and we're going to talk about intellectual property fraud. What do you think about that?
Well, I don't know. I don't know how he defines intellectual property fraud.
Well, usually, from what I've looked up, not being an attorney, of course, it covers things like copyrights, like song, music, or art, or written word that's been stolen, by someone else and used to make money, trademark law, patent law, and trade secrets. So I think we're going to discuss some interesting things because I'm just going to tell you a little story, which I may or may not have shared with you in the past. But do you know the song "The Lion Sleeps Tonight"?
Yeah.
Okay, a pretty popular song. As a matter of fact, one of my friends was a saxophone player on that, and there was a firm out of New Jersey, I guess that represented them on the song, but Disney used their song, they made millions of dollars in the movies and things by using that song, and they made it much more popular. However, there was actually a TV show on a couple of years ago, and on that show it was all about this particular case, because there were African Aboriginal people, and the chant that one of the men created, it was identical as far as the music. It was the same thing, and so he had passed away, but his daughter, ended up getting a lawyer, and she and the other daughters were living in poverty. And she says, "Whoa, I was freaking out when I saw, when I heard the song that my father wrote, on all these Disney things and used for other purposes." So in the end, she actually did win the lawsuit. She's considered a co-creator of that song. But, everyone loves that song, and it definitely has that kind of African sound to it. But little did anyone know until the case came about that it was really a stolen song. So in the end, though, there was a settlement. And so I'm sure they got a substantial amount of money, because I know the original lawsuit was for $1.6 million, and I'm sure that Disney made a heck of a lot more money than that, using that song. So that's just an example of, what happens when someone gets your music. And so for me, I'm a musician, and I wrote a song recently, and so now I have to investigate how do I protect that song from other people stealing it, putting it on websites. And I think a lot of it becomes complicated because you have to track these people down. And I just want to give you one more thing. In all these years I've been doing radio shows, if you remember way back when you did my first consumer advocacy show, which was the Half Empty, Half Full consumer advocacy show, the station said to me, "What song would you like, as an opener?" And I wanted to use "We Are the Champions" by Queen. Well, you're only allowed a certain amount of seconds of a song to be considered fair use, whereas my opening was over a minute of "We Are the Champions" because it fit the show so well. So when I eventually loaded all of these shows up onto YouTube, I got hit with a copyright block. They didn't ask me to remove it, probably because they said, "Hey, it's for a consumer advocacy show," but I could never monetize it. So when you have radio shows or any type of show on YouTube, their system is monitored either by ASCAP or BMI, I believe, and they pick up these songs that are already copyrighted and report back to the copyright owner, and then it's up to them to decide whether or not to allow you, the person that's used it, you know what I'm saying, to be able to use it, or you have to take it down. And that was a mouthful. Storm?
Yeah, can you hear me?
Yep, I can hear you now.
Yeah. You know what I was going to say, and that was what led into my question, is how do you know if and when somebody is committing, intellectual fraud? Because in your mind, this was not something purposely that you did. You thought you did everything right. And then all of a sudden, you don't want somebody coming out of the woodwork and saying, okay, you owe me $1 million, Laurie.
Right. Well, I think usually they do a cease and desist letter first if it's so similar, and if it's not that similar. See, part of the thing with music, Storm, is that songs use chord progressions. And so, if you ever notice like 50s rock and roll, it all kind of sounds the same in some respect. It's because the chord progressions are very similar or the same, and they're changing the melody. So it's a hard thing to decide. I think in music, it has to be really similar. With The Lion Sleeps Tonight, it was identical, basically. It was identical. And so there was no way that Disney could say it was not that particular song. I think the harder part is finding out when people plagiarize things. So just as another example, it was on Facebook not too long ago, and there was a Facebook article. It was artists who were interviewed, and their artwork, where they showed in one picture their original signed artwork, and then on the other side it showed that a major company, Walmart, Amazon, some of those kind of companies, would take their original artwork and incorporate it into some type of a product or on clothing. And what happens is it becomes very expensive for that artist because, the big companies know that these, artists probably don't have any money to file a lawsuit. And so then it becomes increasingly difficult. How do you protect yourself if you're the artist, if you are the owner of the song, or even if you're the owner of a patent, for an invention? How do you protect yourself? And how you find things, and you might know this one, is you can Google, or a website called TinEye allows you to reverse Google an image, and it goes through their system, and it will pop up if it's being used anywhere on the internet. So things I've done, like if I've written something and I want to go, I wonder if anybody else has stolen any of the written stuff I wrote, I will copy and paste maybe a line or two into Google, and I'll see has anything identical shown up. So those are ways you can find out if somebody else is using it. I think the problem is trying to stop it, and especially if you're in the United States and they're a foreign country, I don't know what those laws are, but it's got to be very difficult.
Well, the good thing about it is we got an expert on our show today that's going to tell us how it works and how to stay safe, and if someone has ripped us off, how to go after them.
Exactly, and he'll be on in about another 7 or 8 minutes. So do you have any new things you'd like to update the listeners with today?
Well, there's another lawyer. He's one of Neil Garfield's acolytes that just got slammed by the Justice Department. He was ripping off Hispanic homeowners in Florida, and they've just gone after him with all of his nonsensical arguments, all of Neil Garfield's arguments he was making, and they basically said this is just a total ripoff. He's ripped off all these homeowners by making all these stupid arguments, so they're after him. It's amazing how many of these scammers and con artists are right there ripping off homeowners. And, it's just, again, we're in a position where we try to educate the public. This is why we created this show. Not only is it to educate public about, intellectual fraud, but fraud against homeowners, fraud against whatever. I mean, it's necessary and imperative that the only way that people can protect themselves from fraud is to educate themselves that's why we created this show, so we can help educate the people on what might pop up and what might be a danger to them.
Right. And, over the weekend, I'm not sure what show it was, but I caught part of a show on one of the news channels here. This one's even scarier. So are you familiar with Alexa?
Yeah.
Okay. So we have a couple of Alexas here. I know there are other companies that make similar things. And on this show, what they basically said was, Alexa is listening all the time. Ooh, she heard me say her name, and she just lit up. She's listening all the time and waiting for her keyword or a word that sounds similar to the keyword. But what these experts were saying was Alexa may be sending back the recordings or things that are said in a room after you say her name. Now, no one's really sure before, but it's questionable in that one of the things they mentioned was, well, what if there's a lawsuit? Will an attorney be able to go after the company that makes Alexa and say, hey, we want to subpoena all of everything that was heard, through that system. I know with Alexa also, if you have the one that shows videos, they're saying that it's possible you're being videoed. And so, it becomes more frightening that everything is so invasive. You think it's something that's doing good for you, that's helping you or it's answering questions for you, but it may have more evil ideas than we think about. What do you think?
Well, you know what? Did you see the movie, the guy who supposedly that showed that the CIA and NSA and everyone was listening in?
No, I didn't see that. Was it a movie or a real show?
Yeah, it was Ed Snowden's story. And he was the guy, he was the whistleblower that turned it all in. And what he did was he knew what was going on. So in the movie, he takes a piece of black tape and puts it over the camera. So in the show, he was getting a little frisky with his girlfriend. So he put a piece of black tape over because he knew that not only could they listen, they could watch. They could watch.
Yeah, that's scary.
It's really scary.
Yeah,
so,
and here, I've got a couple of canary cameras, and those are like little cylindrical cameras that I have in the house, like in a couple of different rooms, that let me, through an app, see what's going on because my dog is at home alone sometimes. And I sit here and I go, wow, I wonder if it's watching me now, without, what I'm saying? Is someone from the company still recording the video ongoing whenever there's motion in the room or not? Because when I'm home, my app says I'm home, but could they still be recording me? That's a little scary to me.
You know what else is scary is, these DNA, like 23andMe and the rest of them?
Yes, I've been reading on that. Yep.
Yeah, the government has been subpoenaing the records of people to see if there's anybody there that they can run through their database to see if they've committed any crimes.
Huh. Well, that would be like an ACLU type of case, wouldn't it? I mean, to me, that, I don't know. You have facial recognition on Facebook, too. And listen, Storm, when I post pictures of my other half, it recognizes him as a friend of ours, that they look similar, but not that similar. They both have gray hair, they're both tall, they're both thin. But every time not every time, but maybe from certain angles, it will post our friend's name as my other half when it's not. So I wonder how much room for error there is in these types of systems. But the fact is, I'm starting to believe that people are listening. Do you have to now think about, is your house being bugged because you have Alexa or because you have, a camera? My Alexa one night went off in the middle of the night. She'll just start talking. She'll start spinning in circles. I'm like, what the heck? I haven't said anything. I've been asleep. So I think it's kind of a concern.
Well, you know what? That might be an interesting question to ask our guests because, theoretically, if you're in your, if you go outside your house, anything that happens once you cross that threshold, whatever happens outside is basically free for anybody to do. At least that's the government's argument. But if you're in your house and Alexis is collecting information on you, is that intellectual property? My argument would be that it is.
Because it's happening in your home, you're saying?
And it doesn't even have to be that far-fetched that you're composing a song. But, I mean, if you're in your home, you're having discussions about maybe something you're going to invest in or something maybe you shouldn't invest in, are they, by listening in, stealing your intellectual property? That's a good question to ask him.
Yeah. All right, well, keep that in mind. Let's go to a commercial break. And we come back, hopefully we'll have Eric on the phone with us. So stay with us.
Have you received a notice of foreclosure on your property? Do you suspect that you're involved in an unfair or fraudulent loan agreement? Are you looking for a way to save your home? Would you like to cut through all the misinformation and find out what really works? Would you like to learn strategies that the so-called gurus aren't aware of? If you answered yes to any of those questions, a professional team at Mortgage Fraud Examiners can assist you and your attorney with all of these things and more. Contract breaches, errors, statutory regulatory violations, fraudulent appraisals, and other fraudulent conduct cause most mortgages to be legally problematic. In fact, the Federal Deposit Insurance Corporation found that nearly 2,000 financial institutions they assessed received citations for significant compliance violations. They also examined appraisals and found out that of the 259 appraisals reviewed for accuracy, only 7 fully complied with professional standards. Call us at 844-920-7200. That's 844-920-7200. Mortgage Fraud Examiners, 844-920-7200.
Okay, guys, we're back on AM/FM 24/7 radio with our special guest, Eric Pellenbarg. And the call-in number, if there's any questions, is area code 646-668-8512. Eric, welcome.
Hey, how's it going?
We're doing good.
We got some questions for you, big guy. You think you can handle it?
Well, we'll see.
Yeah. So we've been.
Laurie and I were just talking about if you're in your house, and my theory behind it is that if you're in your house and having a discussion on maybe something that you're going to invest in, or any type of discussion within your house, and somebody like Alexa or the NSA or whoever's listening in, would you consider that to be intellectual property? What's your thoughts on that?
I think that's more of a privacy issue as opposed to an intellectual property issue. Because, I would say you probably need to read the terms of use of Alexa, which everyone likes to click through and not really read, because it probably has something in there about who owns what and all that kind of stuff.
Yeah, because I know it's a privacy issue, but I was just wondering if in fact you could argue that not only is it a privacy issue, that they'd be stealing your intellectual property if you were talking about certain things within your home.
Well, it's not really intellectual property so much because, the intellectual property typically falls into the categories of patents, copyrights, trademarks, trade secrets to a certain extent. So when you're just having a conversation in your house, unless you're discussing, the formula for Coca-Cola, which which is a trade secret, I'm not really sure there's much traditional IP that you're talking about.
Yeah, okay. And so. Yeah, Stormy, Eric, we were talking a few minutes before you called in, and I was talking about there was a show over the weekend down here, one of the news channels, on Alexa and these home devices that they're saying that the experts are saying that they can listen in all the time and they can hear everything that you say, which is a little bit frightening. So if you are talking about something that should be private, what they were discussing was, what if it was criminals and they were going to rob a bank? Could the police, get some type of a warrant for that? So we're saying, well, what if you're talking about intellectual property, like, you're talking a trade secret, or maybe, an invention, something you're coming up with, and Alexa has listened to what you've said, and there have been cases actually with Alexa where she has transmitted conversations to completely different people. It hasn't happened a lot, But I'm thinking,
right.
who's really listening in? And if they did hear a trade secret and then the court tried to pull that, well, would that be legal? So I think that's sort of like a gray area at this point, no?
Yeah, I mean, you have to sort of go back and look at, again, like, I haven't read the terms of use with Amazon. It may or may not say in there how long they retain, the conversations if it's recording. I'm not sure if it's necessarily recording all the time. It's sort of, I think it's triggered by a keyword or, the activate word,
right.
which is Alexa, or, you can name it whatever you want. But, so I don't necessarily know if it's listening and recording all the time. Maybe it is, maybe it isn't. But there's definitely, I'm sure, some sort of consent implied and in those terms of use that says, hey, if you use this device and you say, Alexa, you allow us to record, and, you're not going to make a claim against us for the recording as long as we do use the recording in accordance with how we're saying we're going to use it in this terms of use.
Right. So people have to be careful about maybe now what they're saying if they have one. So I want to give a little disclaimer for you because you're not giving any legal advice. We are strictly talking educational advice so that our listeners, are become smarter and don't get scammed
right.
out of things. So can
right.
you explain now? I have the 4 types of IP as copyright, trademark, patent, and trade secret. So let's start with copyright. Can you explain how copyright works?
Copyright is basically, the legal definition is, written content or something that's, fixed in a form of media. So, it's photographs, written words, audio recordings, television broadcasts, motion pictures, stuff like that. So that's sort of the general area that the copyright is going to protect.
Okay, and we're going to come back on these now. What exactly is a trademark? That's for a specific company.
Trademark is it's more for protecting the source of goods and services. So it mostly a lot of times businesses obviously will use trademarks as signifiers of source. So with restaurant services, there's a trademark for McDonald's, and that signifies. They have a trademark for the word McDonald's. They have a trademark for the Golden Arches because they're a purveyor of burgers and whatever else. And they want to know that when you see the Golden Arches or when you hear the word McDonald's, when used in connection with restaurants, you always think of them. And no one else is out there selling, substandard burgers, fries, milkshakes, whatever under the same name. And that's going to cause confusion amongst the consuming public, which is what trademarks are for, is to keep the consumers from being confused as to where they're getting their goods and services from.
Gotcha. I know on the copyright it has a little C, and on the trademark it has a little TM normally next to it.
Well, it has a TM before it gets registered, and once you register it with the federal government, then you get to use the circle R, like the circle C for a copyright, but you use the circle R for a trademark. Right.
Now, I've also heard of service marks. Is that different?
Service marks are, I remember I spoke of goods and services, so the trademarks are sort of divided up into goods and services, and you can use service mark for services, say, consulting services or entertainment services or whatever you want to do. You can use service mark, but most times people just use trademark interchangeably for goods and services because it's just kind of easier that way.
Okay. And then a patent is what you do on an invention, correct?
Patent is, it's the way the physical manifestation of an idea. So an idea in and of itself is not patentable. It's the way you implement that idea in a practical manner. That mechanism and that methodology is patentable.
Got you. And then I know trade secret, you mentioned Coca-Cola. That's companies that have something that's so specific to them that no one else can have it, and they typically don't have to reveal it, like even in court, correct?
Well, trade secret, right. So if you have a formula or a way of doing something, and it's secret, then, as long as you maintain the secrecy, then you can keep that secret indefinitely. That's the upside of a trade secret versus a patent. A patent has a limited duration of, 20 years. So for when you file the application to patent it, but a trade secret can be of indefinite duration as long as you maintain the secret.
Got it. Okay, Storm, do you have any questions before I go on?
Yeah, I did have one question. Is there such a thing as a common law copyright, or do you have to go to the government to get a copyright?
I mean, you have copyright protection from the moment that you create a copyrightable work. So if you're writing a story or whatever, and you sit up there and pull up Word and you write a story on your computer, and as soon as you're done writing it, then you save it. Like, you have a copyright in that work. It's just unpublished and it's unregistered. So you have rights, but in order to, take action and enforce those rights, you really need to register the work.
Okay.
Right. And you can do that with the Library of Congress, because I've copywritten music. And then the only problem, I guess, that the Library of Congress, it takes, they say now, like 1 to 2 years to get the song actually through it. So I have to remember not to cancel my checking account where I wrote the check, because 2 years is a long time to get the copyright.
That's pretty long. I mean, the copyrights I've done, I'm not sure why it's taken me that long. The ones I've typically done usually take on the order of like 6 to 8 months.
Okay. We were talking a little bit earlier before you joined us about are you familiar with the Lion Sleeps Tonight, the lawsuit with Disney?
Vaguely, but, yeah, a little bit.
Yeah, that's the one where it was originally like an African or Aboriginal song, and company in New Jersey, I guess, was the publisher. And long story short, the daughter of the man who wrote it was deceased, but they had recorded it in Africa. And when they compared the recording of the one in Africa to the one that was being used by the people who did it now, it was identical. And long story short, there was it settled out because the song was that close. But one of the things with music is, if I write music, and how do you know that someone else hasn't written something with the exact same song unless someone comes forward and says, hey, my song sounds just like that? Well, what happens to me then? I'm assuming they do a cease and desist first, but they probably have to prove it or send you a link that says, hey, I did this. So with the copyrights, if someone else had the same idea or similar artwork, how can someone like me protect myself?
Well, I mean, honestly, if you create, this is kind of the unique thing with copyright, though, is there's this thing called independent creation. And so if you were living on an island and came up with, Mickey Mouse and Donald Duck and, princesses and all this other kind of stuff, and it looked exactly the same as the Walt Disney one,
right.
There would be no there's no copyright infringement there because you created it independently of Disney's. So
okay, but you're saying though I couldn't.
So my point to what you were saying was you're like, well, if somebody comes up with the same song, well, if you came up with the same song on your own, and you had no way of accessing or knowing. Now it's a hard thing to prove because if somebody's coming to you with a famous song, you can say, well, I never heard that, but it's going to be hard for you to say, well, you never heard this song that's been played over for 50 years all over the place. It's a little bit of a difficult argument to make, but I'm saying it's possible to avoid a copyright infringement claim if you independently come up with something on your own.
Gotcha. And one of the things, and sorry, I'm doing most of the talking here, but one of the things I saw was an article on Facebook where they interviewed artists who had their work stolen. They had the original artwork, side by side in a picture, their original artwork signed, and then they would say, hey, here's my artwork on somebody else's, some major corporation's products, because now you can search pictures through Google or TinEye. And the biggest problem that they had was they don't have enough money. They can send the cease and desist, but now they have to find an IP attorney, correct, in order to actually try and stop it. And the problem is once it hits the Internet, it's all over the place. So what do you do if you're in that situation?
Yeah, I mean, honestly, that's sort of the thing is, at that level, it's important to, that's why it comes back to having really, registered your work, because under the copyright regime the way it is now, if you don't have it registered, the only thing you can really sue for is what are called actual damages, which is, you have to prove what you're actually damaged, right? How their infringement, actually, pulls money out of your pocket, right? Which for a lot of smaller, independent creators, independent composers, or whatever, that, aren't selling, aren't consistently turning out top 40 hits, that's tough. That's a tough thing to do, right? But if you register your work, you can get what's called statutory damages, which are damages that are independent of your actual damages. The statute just says, okay, if you're infringed, you get damages in the amount of X, and it can be a lot of money. So, and in that case, also, if you have a registered work, the statute can provide for you to get attorney's fees if you win. So the moral of the story is to register the work, spend the $35, because if you go to an attorney and you have a registered work and this person's infringing, the attorney is much more likely to take your case because they may even take it on a contingency because you've got a registration and they have a right to try to get fees. So more likely they're going to get paid with a registered work than if you just walk in there and say, somebody stole my song, now let's go register it now and sue them. They're going to say, okay, great, you can pay my fee, but it's probably not going to be worth it.
Gotcha. All right, well, let's do this. Let's go to a quick commercial break. So everybody stay with us. We'll be back in a moment, and we're going to talk more about intellectual property and fraud.
There is a very high likelihood your mortgage contains an extensive error. At Mortgage Fraud Examiners, we know just how costly a missed opportunity can be. For almost 40 years, we have consulted, retained, and referred to by attorneys, lawyers, trial practitioners throughout the nation. Put another way, we are the trusted source for litigation support. A foreclosure is basically an allegation the homeowner breached the contract by failing to make timely payments. The contract is clear. The borrower promised they would make timely payments, and if they didn't, the lender could take the property. The only way to overcome the homeowner's breach is to show the lender breached first. Identify errors that would void the contract. Identify regulatory violations. Identify appraisal fraud and other fraudulent contact. And the only way to find these wrongs is to thoroughly examine the whole mortgage transaction. This meticulous examination of your mortgage transaction and appraisal can identify legal defects that would make your mortgage unenforceable and entitle you to compensation or even free title to your property. Call us at 844-920-7200. Mortgage Fraud Examiners, that's 844-920-7200. 844-920-7200.
Okay, listeners, we're back on AM/FM 24/7 radio. The call-in number's area code 646-668-8572. We have our special guest, Eric Pellenbarg, an attorney dealing in intellectual property law. Eric, got a question for you. I know fraud is a very generic term, but what is intellectual property fraud? Can you define that for us?
I mean, I'm not really. It's kind of a fuzzy one. I mean, I would try to rack my brain as to how to actually do that. I think, I think infringement is obviously a sort of a method of fraud because you're pawning off your goods or services or your product as being related or associated with somebody else's, right? You're trading on the goodwill of McDonald's, the example I gave earlier, with your stuff. Another thing, something else that I see that's a little bit on the fraud and the thing is when we register trademarks for people. I work at a company now. I'm not in private practice, but I register trademarks for the company, and this happens a lot. Is once you file a trademark application, you get your registration. Your name and your contact info is public record with the government, and so there's a lot of companies out there that will troll and scrape those databases for contact information, for emails and stuff like that. And then they'll try to send you, fake invoices or, hey, put your trademark on this register of whatever, and it's completely bogus, and they want you to try to send them a couple $100 or whatever to do that, or even a couple $1,000 I've seen. So, people can do trademarks and whatnot by themselves, but you have to be aware, hey, this stuff is out there, and the Patent and Trademark Office tries to tell you to be aware of that stuff, but some of that stuff looks pretty convincing. Unless you're sort of reading between the lines, you kind of know what you're looking for. It's easy to get hacked.
Yeah, which kind of begs the question, is there really such a thing as intellectual property fraud?
Like I said, the traditional, fraud is taking advantage of someone or pretending to be who you are when you're saying you're someone when you're not. And so I would think, if you're selling counterfeit goods, that we've run into that and when I was in private practice and also here, that's the fraudulent activity because you're taking someone's intellectual property, you're putting it on a product that's not theirs, and you're selling it for your own gain. So that's a form of fraud.
Right. I think it's hard to protect. Like if I create something, the whole point of the show really is if you create something that falls under copyright, trademark, patent, trade secret, how do you, even if you protect it by registering it or whatever it is that you have to do, the problem becomes how do you stop other people from getting away with it. Now, Eric, I know like what we're talking about has to do with the United States, but what happens in foreign countries? If something happens in a foreign country and the person who owns the intellectual property is in the United States, what happens then? Because is it based on United States law, or you'd have to go to a foreign country to fight it? Like, what happens?
Well, a lot of the times, I mean, part of the problem is, the first problem is it gets expensive to fight that. So that's number one. The other issue is, it's expensive because you have to basically go and find a lawyer in that country to deal with it. There are ways to not have to do that, but they're difficult. And the other problem is, a lot of times you don't have rights in those countries. So, trademarks, for example, they accrue through use of the mark in a certain jurisdiction. So if I have a United States trademark, I get, rights to U.S. trademarks by using it in the United States. Well, the same thing goes for, the European Union. You get rights over there by using a trademark and registering it in the European Union. But the problem is, if I'm a U.S. brand and somebody takes my brand and my name and starts using it in Europe, if I've never used my brand in Europe, I don't have any rights over there to enforce against this person, right? So that's the other problem is then, if you want to grow and you want to get bigger, is it worth it to you to have for the money and the expense to register your trademark abroad? You can register it internationally. There's an international registration. You can do that, and then that will let you, branch out to other countries. Again, it's not cheap to do that. So, there are ways to do it and to protect yourselves, but unfortunately, for smaller businesses or, that kind of thing, it can get expensive really quick.
Well, now, is going to an attorney beforehand a good idea in the case of any of these things that we're talking about, if you think that it's something that would be profitable? And will an IP attorney help them better than them doing it themselves?
Well, I can't speak to any particular situation, but, it's definitely, doesn't probably hurt to, try to find a referral and meet with someone that has experience in this area if, you think there's a potential for, a lucrative business or an entrepreneurial situation where, there could be expansion. I mean, getting an initial set of trademark registrations in the United States, even in a single state, is not overly expensive, and that, can kind of protect you in the U.S. And to be honest with you, I mean, U.S., Europe, Japan are kind of the biggest markets in the world, and so, you can get protected in those jurisdictions for not an exorbitant amount of money. So if you think you're going to be global, you can kind of pick and choose where you are, and then you have to kind of deal with customs and things like that to keep out the counterfeits and whatever from that are going to get tried. China is notorious for that, of making counterfeit stuff and then trying to ship it into the U.S. So
handbags.
So
yeah, they do have handbags a lot. I know.
It would appear to me. It would appear to me that it would be probably smart for anyone that was looking to get a copyright or a trademark or a patent, that it would be smart to find a lawyer, because I'm sure you could go to the patent office. I'm sure that, to get a copyright or trademark, someone with two brain cells to rub together could probably do it themselves. But it would seem to me that going to an attorney such as yourself would probably expedite it a little bit versus someone that really doesn't know what they're doing and hasn't done it before. It would be worth spending the money to have somebody do it, because you know where to go, what to say, and how to fill it out.
Right.
I know it would appear to be a prejudiced statement coming from you, but common sense would dictate that that would probably be the best course of method for anybody.
Yeah, I agree. I agree with that, Storm, because, people try to do things themselves cheaply, and then when something really wrong goes wrong, well, they didn't talk to an attorney to begin with, and now they're looking online. And, of course, looking online comes down to due diligence. What source are you looking at? And I think it becomes complicated there, where it's always worth going to an attorney, at least for an initial meeting, to figure out, what the best way is to do it, because everything here can basically be stolen. And I'm sure Eric probably knows a lot of big cases and things like that. But I want to talk a little bit now about the patents and the inventions. So, one of the things that I understand is that with an invention, all somebody has to do after something new comes out is change one thing in that invention, and then they can do a patent on that. Is that correct?
I mean, it depends on what the patent says. I mean, the patent basically, lays out, the patent is the disclosure of your invention, right? So that's the trade-off that the government gives you. It says, we're going to give you a monopoly on your invention for 20 years. And the trade-off for that is that you have to make a public disclosure of what your invention is and how to do it. You know? So that's the trade-off. So the short answer to your question is maybe. It depends on what the tweak is. You know, if you have an invention that is it's got steps A, B, C, and D, or parts A, B, C, and D, right? Those are 4 different parts, and you come up with that. And that's your product, right? Well, if my thing is I do A, B, C, D, and then I add E, right? But if I'm doing the 4 that you've said, then yes, I'm infringing, and then I can't just add something on and do it. But if I change the way I do it, if I do A, and then I come up with E, and then C, D, and E is something new that you didn't come up with, then yeah, it's probably not an infringement unless there's some technical ways to combat that. But I'm just generalizing. Then yeah, if you change something, there's a potential that they can get around your invention. It's called designing around. That's what they do.
Wow. So I mean, it's almost more profitable to wait till somebody invents something, and if you have money, and then change it a little bit, and then you don't even have to think about the idea. It doesn't seem fair. But I'll just really quickly. I know
depends on how good they write their patent.
Yeah, that's what I would think, because I know someone who invented it's called the brushless paw wash, and so for dogs that are coming in from the house that are before they treat the mud, if maybe you're in an apartment or you don't have a hose to do it. This young lady at the age of 12 invented this invention. She's I think in her late 20s now. And it's almost made to like a long kind of hourglass shape, so that when it's filled with water, you put the dog's paw in, and then when you pull it out, because of the narrow center, it kind of keeps the mud down in the bottom. And it's a pretty good idea for an invention. But what I've noticed now is I see couple other companies coming out with not exactly the same design, but coming out with something that they're almost identically naming it. And I'm sitting here going, wow, this girl's been doing this for years and years, and now here are these 2 other companies that jump on the bandwagon, basically took her idea, modified it, and now they can patent it.
Yeah, I mean, again, I don't know without having really looked at it and what the unique facts are. It's kind of hard to say, but I would assume they've done their homework and figured out a way to get around whatever she was doing.
Eric, let me ask you and I know there is some confusion, and this would help some of our listeners. What is the difference between a copyright and a trademark when it comes to expressive language?
Well, again, they sort of cover 2 different things, right? So short phrases or short slogans or whatever that you would use for a trademark are not really copyrightable, because they don't really have enough sort of unique and artistic content.
Okay.
So they sort of cover 2 different things, like if that makes sense.
Which kind of brings me back again to why it would be worth seeking out an attorney such as yourself, because you might have somebody that says, well, I got this little slogan, so what I'm going to do is I'm going to copyright it, but the copywriting really doesn't cover it. It really should have been trademarked. And if they had gone to somebody such as yourself, you would have, you'd have taken them down to the path to do it properly.
Right. Exactly. Yeah.
So I'm going to jump on this bandwagon here. So is there ever a time when you need to do 2 things, like where you need to both copyright and trademark, or copyright and patent? Like, do you ever have to do 2, or is it always just one of those 4 things?
Well, I mean, no. So, for example, like if you came up with a product, like the Better Mousetrap or whatever, right? And you came up with a new way of making a mousetrap that no one had come up with, you would get a patent on the design or the physical embodiment of the mousetrap that you're going to sell, right? That's a patent. So you're protected on the machine itself, right? Then you would come up with whatever you're going to call it. I don't know, your brand name, Mouse X or whatever the heck you want to call it, and you would file a trademark for that. That's the brand name, the trademark for the machine that's patented. Okay? Okay,
so this is why people need a lawyer.
Yeah, and then if you want to get a copyright, I don't know, say you come up with your website, your content on your website. If you have a brochure, you can copyright that, because that's got written content, written stuff and photos and whatever, so you would get copyright protection on that material. But that's sort of how they all kind of interplay.
Right. Now, Storm, I think you have everything on your website copyrighted, don't you? Because I know I do on mine.
No, I don't.
You don't? Oh,
no.
Well, then I guess it might be a good idea to do that. Well, you know what, guys,
It's kind of hard to copyright because I didn't write a horn book on contract law or any of those things. So basically, what we talk about on our website as far as helping homeowners is really not copyrightable anyway. Which brings me to an interesting question: is the as you know, Eric, the code books that are published by the publishers, that is copyrighted, correct?
I'm sorry, say that again?
The code books that you can buy that the different publishers put out, like the United States Code or Florida Code, that's copyrighted.
Well, I don't know. I mean, I don't think you're allowed to copyright government content. So to the extent, West or whatever publisher is putting out a copy of the United States Code that's published by the government, I mean, they would have copyright protection in whatever sort of unique, cover and whatever materials they have. But the text itself is owned by the government, and you're not allowed to, copyright that.
All right, well, let's do this, guys. I want to go to a commercial break, and we got one more segment to go, and I want to come back and let's talk about trade secrets. So stay with us.
Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. You can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed.
We're back on AM/FM 24/7 radio. The call-in number is area code 646-668-8512. We have our special guest, Eric Pellenbarg, a intellectual property lawyer who's been educating us, on the different aspects of intellectual property law. Laurie, I believe you had a question you wanted to ask Eric.
Right. I want to go over, I know that Coca-Cola is a trade secret. Can you give some examples of other trade secrets, and can you maybe relate a case to that?
Other trade secrets. I mean, Coca-Cola is the most famous one.
Kentucky Fried Chicken. Kentucky Fried Chicken is one.
Yeah, that's one. The 11 herbs and spices or whatever. Yeah. So it's almost like it's a lot of recipes, formulas. I think there's probably some in the medications they typically will file because you can't really do it a trade secret for medication because with all the FDA rules you have to disclose within all that stuff.
Okay.
So you couldn't really have it as a trade secret because the government wants to know what you're having people put in their bodies.
I gotcha.
You can get a patent. You can get a patent on the drug formulation. That's how they protect that and they make money off that is through patents.
Okay, but the trade secret. So if somebody gets hold of I read Facebook at night, but I read all these stories and you always wonder if they're true or not, where someone claimed that they had the recipe to Kentucky Fried Chicken, to the batter, and they actually posted it online. Now, whether that's actually true or not, I don't know. But if it turned out that it was, then that person's going to end up in a heck of a lot of trouble because now it's all over the Internet, and that would ultimately kind of destroy, the purpose of having a Kentucky Fried Chicken to begin with.
Well, yes, but the problem with the trade secret is that if somebody reverse engineers it, then there's nothing you can do about it. So if the person went to Kentucky Fried Chicken 1,000 times and kept tweaking and figured out the recipe, they're free to publish it, and there's nothing KFC can do about it because as long as they didn't get the recipe, through, fraudulent means or steal it or from KFC or whatever, if they came up with it on their own, they figured it out, then they can do what they want with it. That's the downside of a trade secret.
I gotcha. All right, Storm, question.
Same with Coca-Cola. If somebody managed to reverse engineer how to make Coke and make a beverage taste exactly like Coke, That's too bad for Coke.
Didn't know that. Okay.
Where's the line, Eric? Where's the line drawn between plagiarism and copyright law?
Plagiarism, well, I think the legal definition is, substantial similarity, I think, is what they say it has to have. So, it's when you hear a song or you see a story or whatever, and, if there's a substantial similarity between the written word and the original, or the original music and, what is the infringed part, that's sort of the test. But, it varies depending on where you are, because the different circuits have slightly different tests for infringement. So it's a little bit of a moving target in a fuzzy area for sure.
But if you're writing on a subject and you have footnotes, you're not violating copyright laws, right?
Well, I mean, yes, not technically, but at the same time, you can't just footnote something and take huge pages and huge chunks of people's content and put it in your own work, right?
Right.
I mean, you have to sort of make it your own a little bit, and attribution helps, sort of diffuse a copyright claim, but at the same time, you couldn't just go and copy J.K. Rowling's Harry Potter book into your own book and add a couple little notes here and there and just cut and paste. That's not going to work.
Right.
Yeah, I would think if you're doing it for a school project and you were footnoting small sections, because you're not making any profit on it. But if you were stealing it for the purposes of making money, then I think it's a different thing, right? There's two there's two differences.
I think that's right.
It's an interesting subject. Because it incorporates so many other different areas of law. I mean, again, that's why I think it would be necessary and imperative for anyone that was interested in writing a book or writing songs or, wants to come up with a slogan or wants to do something, it would behoove them to seek somebody else, such as yourself, to get the proper advice to make sure that they're protected, or conversely, they're not infringing on somebody else's intellectual right.
Yeah, sure. I think the best advice that I would give would be, and this is when I was in private practice, it's a lot cheaper and a lot more efficient to do it right in the beginning than to try to fix it after something bad happens. And people, when they're starting out, they're, starting a business, getting going, every dollar counts. I get that, but it's going to cost a lot more to fix the problem if it gets out of control versus in the beginning when, it's, a smaller number and people still don't want to spend it. I would always say, hey, that's what it is. But if this happens or that happens, it's going to cost you 5, 10x of that to rectify the problem down the road. You really got to put that in perspective.
Yeah. This is self-defining, but what's the difference between a patent lawyer and an intellectual property lawyer?
Well, a patent lawyer is a specialized practitioner, so you have to go to school, go to college. Undergrad degree has to be in some engineering discipline or science discipline, and then you take a test with the Patent and Trademark Office to qualify to become a patent lawyer. So patent lawyers are more specialized, and they can write patents and represent people in patent proceedings at the U.S. Patent and Trademark Office. All patent lawyers are intellectual property lawyers, but not all intellectual property lawyers are patent lawyers. Does that make sense?
Okay, that makes sense.
So I'm a patent attorney. I am a patent lawyer. I took the test. My undergraduate degree is in chemical engineering, so I took the test, passed that, so I can go to the patent office. But I also do trademarks and copyrights and all that other kind of stuff. Some other people, they go and get a non-engineering, non-science degree, but they still want to do trademarks, and I have plenty of friends that do that, and they're trademark attorneys or copyright attorneys or IP in general, but they don't do patents.
Okay, I got one more question for you. So, I want to go back big companies, using logos, for example. Let's say I decided to create a logo for my business. How would I know? Is there a way to check that logo? I guess online you can do it in Google or TinEye by putting it in. But is there actually a book online of every logo ever made? So if I wanted to scan through and see what all the logos are, or does the Copyright Office, do they actually check to see when you copyright something like a logo that there's nothing else like it, or is it basically just do it and then if something happens, change it?
the Copyright Office, as far as I know, they do not go and do a search and check. If you're concerned about it, the way to do that would be, to go out and retain a IP lawyer and have them run a search for you, which is, a service that's offered by third parties. They'll go, you give them the design, the logo, and they'll go and search. You're more worried about, if it's a logo, you're more worried about trademark side than the copyright side. So they would go and search the trademark database and see if there's anything similar out there and then report back to you, and then you can make a decision based on that.
I gotcha, because that would be a big mistake if it was a big company and they came out with a logo that looked like somebody else's, and now they'd have to do damage control and then change their logo when they should have. When there is a way, you're saying for an attorney to go through and check things out first. So the attorney is really the way to go.
Yep.
All right, Storm. Any last questions?
No, we really appreciate you, Eric, coming on. You educated me. There's a lot of things I didn't know that I do now know. I appreciate that. I'm sure the listeners appreciate it as well. If we want to get a hold of you, can you give us your coordinates on how we can contact you, your address, phone number, website, email, and such?
Unfortunately, I cannot, because I am not in private practice, so I'm not able to take on clients or anything like that. So, I work for a company. I'm an in-house attorney right now, so I am not allowed to take outside clients. So, unfortunately, I'm off the market.
Well, that's a shame.
Eric. Yeah, we appreciate you. I appreciate you coming on, and Storm does too, and explaining that to our listeners, because intellectual property is a confusing topic to non-attorneys and probably to a lot of attorneys too. But I think you explained it pretty well, so I want to thank you for coming on the show today.
Sure, no problem. Happy to help out. Thanks a lot.
Thank you. And thanks for joining us today on Fraudsters Radio. Please join us again next Monday from 1 to 2 p.m. Eastern Time live. Remember, we do want to hear your stories, and you can contact us through the Fraudsters Radio Facebook page. All right. Thanks, everybody. Great show.
Bye.
Bye-bye.
Bye-bye.
Have your house payments skyrocketed under an adjustable rate mortgage? Have you been laid off or had your hours cut? Are balloon payments coming due? You need help from mortgage fraud examiners. To stop the housing crisis, Congress and the White House are pinning their hopes on homeowners renegotiating their mortgages. The trouble is, the banks are saying no 80% of the time. Mortgage fraud examiners can help you get the leverage you need to turn things around. They estimate that up to 85% of all mortgages are legally deficient. Mortgage fraud examiners can perform a mortgage transaction analysis and an appraisal to find legal deficits in your mortgage. It's like CSI for your home loan. Banks and lenders suddenly start cooperating when faced with a lawsuit for violating lending laws or appraisal fraud. Find out how mortgage fraud examiners can help you. Visit Mortgage Fraud Examiners. Call 844-920-7200. That's 844-920-7200.